prosecutors used surveillance footage, DNA on a rifle, and a string of text messages to build what looked like an airtight case against Tyler Robinson, the 22-year-old they charged with assassinating Charlie Kirk. The world bought it, and many believed real justice for Charlie Kirk had finally arrived. But one person publicly pushed back long before the latest development that could now prove Tyler Robinson's innocence and point investigators toward an entirely different suspect. For 7 months, Tyler Robinson has been sitting in a Utah jail cell facing capital murder charges, and the prosecution's case against him has been presented to the public as airtight. Alleged text message confessions, DNA on the trigger of the rifle, a suspect who his own father recognized and turned in, a 3-hour drive to the campus, a note found under his keyboard that prosecutors say announced his intention to kill Charlie Kirk before he ever got in the car. The narrative was clean, the timeline was neat, and the media moved on because the story appeared resolved. But resolved cases do not generate the kind of court filing that Robinson's defense team dropped on March 27, 2026. And resolved cases do not end with the sheriff who orchestrated the suspect's surrender quietly handing in his resignation badge on the very same day those filings became public. That is exactly what happened, and both developments deserve to be examined for what they actually reveal about a case that has never been as solid as it was presented. Robinson's defense attorneys, led by Catherine Nestor, filed a motion in Utah's 4th District Court requesting that his preliminary hearing, scheduled for May 18th, 19th, and 21st, be pushed back by at least 6 months. Their stated reason was that they had not received the complete evidence they are constitutionally entitled to before any hearing of this nature proceeds. But buried inside that motion was the detail that changed the entire conversation around this case, and it did not come from the defense team's opinion or legal strategy. It came from the federal government's own forensic analysis. Before we go further, this channel is relatively new in the block. We launched with a mission to cover the cases that deserve more than a headline, and we are going to keep doing that. But the only way we know this work matters to you is if you hit that subscribe button right now. And honestly, between you and us, we are trying to hit 1,000 subscribers before the end of April 2026. If you want to be part of that movement and watch us grow, now is the time. Subscribe, hit the like button, and let us keep going. The rifle at the center of this case is a Mauser Model 98, chambered in .30-06, a bolt-action weapon that had belonged to Robinson's grandfather and been passed down to him as a family heirloom. Prosecutors say that rifle was the murder weapon. They say Robinson carried it 3 hours from his home in Washington, Utah, to the campus in Orem, fired a single shot from a rooftop approximately 142 yards from where Kirk was standing, then fled and left the weapon wrapped in a towel in a wooded area near the university. The FBI recovered it.
Was etched, no Tice's bulge, OWO, what's this? The second cartridge that was again
DNA consistent with Robinson's was found on the trigger, on the fired cartridge casing, and on 2 unused cartridges. On the surface, that sounds definitive. The Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted its own independent analysis, and it could not make the connection the prosecution's entire case depends on. According to Robinson's defense attorneys, citing the ATF's own summary report in their court filing, the agency was, in the filing's exact words, unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. That is not the defense's interpretation of the ATF's findings. That is the ATF's own conclusion about its own examination. What this means practically is that the federal government cannot confirm that the bullet which killed Charlie Kirk was fired from the rifle tied to Tyler Robinson. The The defense intends to put the ATF's own firearms analyst on the stand at the preliminary hearing to present that finding as exculpatory evidence, meaning evidence that in their argument points away from guilt rather than toward it. CBS News legal contributor Jessica Levinson offered context worth understanding. The inability to match a bullet recovered at autopsy to a specific weapon is not automatic proof of innocence. Rifle rounds can expand and fragment significantly on impact, and when that happens, the microscopic barrel markings forensic examiners rely on to make a ballistic match can be partially or entirely destroyed. An inconclusive result, she noted, means there is insufficient evidence to reach a conclusion, not that the bullet definitively did not come from that rifle. That context is important, but so is this. The prosecution in a capital case, a case where they are seeking the death penalty, must prove every element of their argument beyond a reasonable doubt. The chain they need to establish is specific. This suspect, this weapon, this bullet, this victim. If the Federal Firearms Agency cannot confirm the connection between the weapon and the bullet, the defense now has a forensic gap sitting at the very center of the state's case. And in a courtroom where Tyler's life is on the line, a gap at that level is not a footnote. It is the foundation of a reasonable doubt argument that his lawyers are already building. The FBI, according to the court filing, is currently conducting a second comparative bullet analysis as well as a bullet lead analysis. Neither has been completed. The defense has stated clearly that until those results are available and independently reviewed by their own experts, Robinson cannot receive the fair preliminary hearing his constitutional rights guarantee. They have also disclosed that prosecutors provided them with a hard drive containing 31 hours of audio files, more than 700 hours of video footage, and 600,000 data files, on top of the 20,000 electronic files already provided. An additional document review of that volume, their filing states, will require approximately 60 days alone just to assess what may be missing. This is where Candace Owens enters the record, and where the record needs to reflect that she was ahead of this story by months. While most commentators were accepting the prosecution's framing of this case as settled, Owens was consistently raising questions about the physical evidence. When the ATF finding became public on March 30th, her response was not surprise, it was vindication. She posted publicly, calling out those who had dismissed her concerns, and noted that the ATF finding confirmed what she had been arguing. She also raised a claim that, as of this recording, has not been independently confirmed through court documents, but is now impossible to dismiss given the ATF context, that approximately 7 sets of fingerprints were found on the rifle recovered at the scene, and that none of them matched Tyler Robinson. She also pointed to the bomb-sniffing dogs deployed at the scene after the shooting, dogs that failed to locate the rifle, which was subsequently found by the FBI when they arrived on site. Owens argued that a recently fired high-powered rifle should have been within range of any trained detection dog working that area, and that the failure to locate it raises a question about whether the weapon had actually been fired at the scene at all. These remain Owens' claims, not confirmed findings, but given that the ATF has now confirmed it cannot match the bullet to the rifle, the threshold for taking these claims seriously has shifted considerably. Now here is the question the whole internet has been asking since this filing dropped. Could Tyler Robinson actually walk free? The honest answer, based on the state of the evidence, is that it is possible, and his defense team appears to be building toward exactly that outcome. The preliminary hearing, if it proceeds, is where prosecutors must demonstrate probable cause that Robinson committed the crime. If the defense can introduce the ATF analyst's testimony and establish in front of a judge that the foundational ballistic link cannot be made, that is not just a speed bump for the prosecution. That is a structural challenge to the case itself. Add the DNA complexity, multiple genetic profiles on key evidence items that the defense says require forensic biologists, geneticists, and statisticians to properly interpret, and the picture the prosecution presented to the public as overwhelming is revealing itself to be considerably more contested than anyone was told. The prosecution, for its part, has stated it intends to proceed and has indicated it believes it has sufficient evidence. But sufficiency in a press statement and sufficiency in a capital murder trial are very different standards, and the gap between them is where Robinson's defense is working. What makes this even more significant is the nature of the hearing itself. A preliminary hearing in Utah is not a trial. It is a threshold proceeding where prosecutors must convince a judge that probable cause exists to send the case forward. That is a lower standard than what a jury would require at trial. And yet, with the ATF finding in hand, Robinson's defense attorneys are now signaling that they may challenge probable cause at that stage, using the government's own firearms analyst to argue that the foundational link between the suspect, the weapon, and the killing has not been established. If that argument lands even partially, the implications for the prosecution's ability to proceed toward a capital trial become considerably more complicated than anything the public has been prepared for. While the courtroom battle over the bullet has dominated the conversation, there is a layer of this story that the mainstream media has not touched. And it centers on a man who, by his own public account, was in multiple locations connected to the events of September 10th, who has inserted himself into this investigation publicly, and who has refused to cooperate with the people asking the most basic questions about what he saw that day. His name is Phil Lyman. He is a Utah state politician who ran for governor against Spencer Cox, then lost. He is not a figure on the fringe of this story. He placed himself at its center within hours of the shooting and has not stopped talking about it since, until the questions got too specific. Lyman has stated publicly, in his own interviews, that he was backstage with Charlie Kirk in the minutes before the shooting. He was at the stage. He was throwing hats with Kirk's team. He then moved away from the stage area to meet friends, and by his own account on a later Instagram video, that movement took him toward the upper level of the venue, an area he described as being very close to where the shooter was ultimately determined to have positioned himself. He heard the shot from that location. He said publicly that he immediately determined the shot had come from a rooftop and estimated it as approximately a 200-yard kill shot. Then there is the driveway. TMZ obtained surveillance footage from a residential street near the campus, captured the suspected shooter walking past a driveway at 11:49 in the morning, less than 40 minutes before the shot that killed Kirk. Lyman has confirmed in a televised interview that his gray CR-V was parked in that exact driveway at that time. He says he had pulled in approximately 10 minutes before the suspect walked by. His family owns multiple properties on that street. His car was present on the shooter's documented route, and he had just come from backstage with the victim. None of that, on its own, is evidence of wrongdoing. People are at events. Coincidences exist. But what happened when investigators and journalists began asking Lyman to share what he filmed and witnessed that day is where the story shifts. Lyman gave extensive media interviews in the days following the shooting, on local Utah news, on national conservative programs, and on social media. He described his proximity to Kirk, his proximity to the rooftop, and his proximity to the residential street where the shooter walked. He offered tours of the area to other investigators. He positioned himself as a resource, and then, when a journalist asked him directly to share photographs and video footage he had taken on campus that day, footage that could either confirm or clarify his account of where he was and what he saw, he refused. When pressed further through a student contact who had worked on his campaign, Lyman reportedly showed up unannounced at that student's home, a 20-year-old UVU student, asking questions about the direction of the investigation. According to that student's account, Lyman was nervous. He was asking specific questions about what lines of inquiry were being pursued, and he refused to share any of his footage. He then called the student separately and, by that account, shouted at him for even asking. Shortly after that exchange, Lyman's nephew, Shane, who had publicly walked the shooter's route near family properties and posted photographs of the exercise, including an image of a Converse shoe print at the scene, made his Instagram account private. Lyman himself has not responded to direct outreach from the journalists covering this angle. There is one additional detail worth noting about Lyman's own public accounts that has not been given the scrutiny it deserves. In one interview, he described leaving the stage area and walking toward friends, his account of where he was when the shot rang out. In a separate appearance, he described being near the upper level of the venue, close to the shooter's reported position when he heard the bang. In a third account, posted on his own Instagram at 11:30 that night, he described going back to the UVU campus after the shooting to speak with police officers and students. 3 separate accounts across 3 separate platforms, and none of them tell the same story about precisely where he was at 12:23 in the afternoon when the shot that killed Charlie Kirk was fired. That inconsistency alone is not proof of anything, but it is the kind of inconsistency that investigators ask people to reconcile. Phil Lyman has not been charged with any crime. He has not been named as a suspect or person of interest by any law enforcement agency. Nothing documented here establishes guilt. What it establishes is a pattern, a public figure who placed himself at multiple locations connected to the crime, who initially volunteered to help with questions about it, and who then went silent and hostile when those questions became specific. In any serious investigation, that pattern warrants scrutiny. And in a case where the ATF cannot match the bullet to the rifle and the prosecution's foundational evidence is being contested, the question of what else has not been adequately examined matters more than ever. On March 27, 2026, the same day Robinson's defense team filed the motion citing the ATF bullet finding, Washington County Sheriff Nate Brooksby submitted his resignation after more than 30 years in law enforcement. Brooksby was the central figure in how Tyler Robinson was brought into custody. It was Brooksby who received the call from the retired detective. It was Brooksby's office where Robinson surrendered. It was Brooksby who stood in front of cameras and told the world how it all happened. The Washington County Attorney's Office confirmed that his resignation came hours after a meeting with county commissioners to discuss undisclosed complaints about operations at the sheriff's office. Brooksby denied any wrongdoing. The individuals who filed the complaints then requested that no further action be taken, and that request is being honored. No charges are expected. The official framing is that after 30 years of service, he simply decided to retire. That may be precisely what it is. The timing may be coincidental, but coincidental timing in a case already full of contested evidence and unanswered questions is something this audience deserves to know about, and the official reason for Brooksby's resignation has not been publicly disclosed. This is just one of the many major ongoing cases unfolding across the United States right now, and this channel is built to cover all of them with the same level of depth and accuracy you just watched. If you want to be notified the moment we drop the next update on this case or any other, subscribe to this channel and turn on your notification bell so YouTube puts it directly in front of you. We are genuinely curious what you think about the Phil Lyman, the Brooksby resignation timing, and the Candace Owens question. Drop your take in the comments below, because the best investigations are the ones where more people are paying attention. We'll see you on the next one.